The Supreme Court appears keen to throw out a Federal Election Commission limit on how much campaign money can be used to repay a candidate's personal loan after an election. Currently, the FEC allows a candidate to lend their campaign an unlimited amount of money, but only permits repayment of up to $250,000 within 20 days after an election. The repayment limit is meant to prevent such loans from becoming a way to bribe candidates who go on to be elected officials. For instance, if a candidate lends their campaign $100,000 before an election, they can charge whatever interest they like. Then, if they win the election, donors can help to not only pay off the loan, but also the interest. So the candidate-turned-lawmaker could net tens to hundreds of thousands of dollars in profit, even with the limit in place. The people or corporations paying off the loan could expect beneficial policies in return. Senator Ted Cruz brought a lawsuit against the FEC seeking to change the limit, after loaning his campaign $260,000 and, seemingly intentionally, waiting more than the 20-day window after the 2018 election, to pay himself back the permitted $250,000. Government lawyers allege that Cruz manufactured this conflict in order to bring a lawsuit, and allow the conservative Supreme Court the opportunity to throw out the repayment limits. Once the 20-day deadline elapsed, the Commission's regulation required that $10,000 of the $260,000 loan be recharacterized as a contribution from Senator Cruz to his campaign. Senator Cruz then emailed his campaign staff, saying, "Since more than 20 days have passed, it would be really good if we could pay back at least some of the $250,000 now." The FEC has stipulated that the sole and exclusive motivation behind Senator Cruz's actions in making the 2018 loan and the committee's actions in waiting to repay them was to establish the factual basis for this challenge. The court's conservative justices were skeptical of the government's argument that Cruz's self-inflicted injury negated his right to sue. Justice Clarence Thomas suggested that a black man's decision to sit in a whites-only rail car in order to challenge segregation would fall under the lawyer's self-inflicted injury standard.
Going back to your standing, you said a number of times that these self-inflicted injuries can't be a basis for standing. At least that's what I understand. But how would you, using that at that level of generality, what would you say about Plessy sitting in the wrong car?
We would not say that that is self-inflicted in the relevant sense.
Why not? I mean, it's just all he has to do is go to another car.
That is, Plessy is attempting to assert a legitimate constitutional right and is attempting to do something in the real world that presumably he would do if the law were not on the books. That is, if there had been no law mandating segregation on the means of transportation, presumably Plessy would have sat in an integrated section and would have had an interest in doing so. This is a case in which the plaintiffs did something they would not otherwise have done solely for the purpose of being injured and then filing a suit.
Chief Justice John Roberts was the only conservative justice to express any opposition to Cruz's lawsuit. It therefore appears very likely that the Supreme Court is about to allow unlimited repayment of loans, with unlimited interest, from donor money after an election. In many other contexts, this would be called what it is: bribery. The Supreme Court agreed to take up 2 cases seeking to eliminate race-based affirmative action in college admissions, an outcome that would overrule the court's landmark 2003 decision allowing the practice. The 2 lawsuits, against the University of North Carolina and Harvard University, were brought by a conservative group called Students for Fair Admissions. Despite the name, we do not know what students, if any, are plaintiffs in the lawsuits. SFFA argues in both cases that the university's consideration of race in admissions violate Title VI, prohibiting discrimination on the basis of race, and the Constitution. UNC defended its admissions policy, saying they have found that no alternative would produce a student body about as diverse and academically qualified as its holistic, race-conscious admissions process. In the last major affirmative action case to reach the Supreme Court, Fisher v. University of Texas, the justices just barely protected the practice in a 4-3 split. Roberts, Thomas, and Alito all dissented and would have banned affirmative action in admissions policies. With this in mind, it is likely the Supreme Court will side with SFFA in a 6-3 ruling. Before we move on, let's talk about the impact that affirmative action policies have had at universities. For much of American history, elite colleges and universities were largely reserved for wealthy, predominantly white Americans. Affirmative action provides more equitable opportunities for a top-notch college education. The average white family today holds more than $170,000 in net assets, compared with just $17,000 for the average black family. Affirmative action benefits all students by exposing them to diverse perspectives on campus. Experiencing a diverse student body in college is associated with having diverse friendships, greater civic engagement, and positive racial attitudes many years after graduation. Affirmative action leads to more diverse leadership, which is essential for sound decision-making and legitimacy. National unity and effective governance require that people of all racial groups should see themselves in the leadership of the country, which signals that people like them are included in social opportunities. Furthermore, numerous studies have shown that colleges with affirmative action policies have a higher percentage of students of color. At Harvard, specifically, the proportion of African American students would be expected to drop from 14% to 6%. And the proportion of Hispanic or other students would be expected to drop from 14% to 9%, without a race-conscious admissions program. Justice Clarence Thomas has been a steadfast foe of affirmative action for the entirety of his time on the bench. During Fisher v. University of Texas's first visit to the Supreme Court, in 2013, he wrote that the argument that educational benefits justify racial discrimination was advanced in support of racial segregation in the 1950s. Race can only be taken into account, he says, when necessary to provide a bulwark against anarchy, or to prevent violence. According to The New Yorker, much of Thomas's skepticism flows from his rejection of diversity writ large. Diversity, in his reported view, does not benefit students academically, or even produce diverse leadership. It just helps beautify classroom aesthetics, which are critical to the self-image of the ruling class. Crucially, his wife, Ginny Thomas, sits on the advisory board of a conservative organization that is backing SFFA's anti-affirmative action lawsuit. This is an obvious conflict of interest that calls into question his ability to hear the case impartially. Ginny not only supported Trump's 2016 and 2020 campaigns, she cheered on the January 6 insurrectionists and attacked the House committee investigation. On the 6th, Ginny posted links to watch the MAGA crowd descend on the Capitol, adding, "God bless each of you standing up or praying." Then, last year, she signed a letter denouncing the January 6 committee for political harassment and demagoguery. The actions of Representatives Cheney and Kinzinger on behalf of House Democrats have given supposedly bipartisan justification to an overtly partisan political persecution that brings disrespect to our country's rule of law, legal harassment to private citizens who have done nothing wrong, and which demeans the standing of the House. We ask that the GOP conference meet immediately to vote on stripping Representatives Cheney and Kinzinger from their membership in the GOP conference. Less than a month later, Justice Thomas was the only judge on the court to say he would grant Trump's request to shield his White House records from the committee. Thank you for watching. If this video has been at all helpful or informative, please consider supporting me on Patreon.